Hi everyone. Thanks for coming here today. I'm Benetta, a legal associate with our firm. And to start off, on behalf of our firm, Cheong LLC, I would like to extend our appreciation to each and every one of you for taking the time off to support our firm's webinar session today. By way of introduction, we are a boutique IP law practice based in Singapore, and we operate an office in KL, Malaysia as well. So in terms of the services that we provide, we offer a comprehensive range of IP services such as prosecution, enforcement, commercialization, as well as strategy work. And we are specialized in assisting with our clients in managing their IP portfolios and with a particular focus on the Southeast Asian and Indian subcontinent region. So today our speaker will be my colleague Shannon, who is based in our Singapore office. And Shannon is a patent executive with our firm who specializes in patent prosecution, and she has assisted our clients from a wide range of industry in terms of management of their patent portfolios. So she'll be sharing more on patent filing strategies as well as how to protect your inventions across multiple jurisdictions. So before we start the presentation proper, please, if you have any questions that you would like to ask, do ask them in our Q&A pop-up on the right side of the screen. And we're having a Q&A session after that as well. So Shannon will be answering our questions along with our director, Ka Liang, who will be coming later. So please stay tuned to the end of the webinar if you want your questions to be answered. And so now, Shannon, please.
Hi everyone. I will be talking about international patent protection. So we'll be going over certain considerations and whether or not you should file a PCT application. So there's just a summary of what we'll be going over. First, I will cover the basic requirements for a patent. Then we'll go through the general outline of the patenting process, followed by how to decide which countries to file in. Then we'll do a comparison between international applications and domestic applications. So first, before you file a patent application, you need a patent specification. So this is basically a disclosure of your invention, like what it is and how it works, because this disclosure is what you give in exchange for the monopoly that patent protection provides. A patent specification usually comprises description, claims, and drawings. So this is an excerpt of a description. It's usually much longer than this. Then you have claims, the claim section, which is the section that defines the scope of protection. So whatever you're claiming is what you're trying to protect. We also have drawings, which are meant to help with the understanding of the invention. So there are certain requirements for the breadth of information that should be included in a specification, and the claim language makes a lot of difference. So it may be wise to consult a professional to help you draft your patent specification. Then it will help you encounter less issues in the long run. So what exactly can be patented? A patent protects an invention that can be a product or a process. For example, I have my water bottle here, which is protected by a patent. So on the bottom, it has the patent numbers. It's protected by a few patents. So usually, if products are patented, you can find the patent number somewhere on the packaging or on the product itself. So the patents for this water bottle cover the one-handed operation and also how it can prevent leakage when it's open. So this is just an example of a product that's been patented. But not just any product or process can be patented. There are three most basic legal requirements for a patent to be considered patentable. So the invention has to be novel, inventive, and useful. So officially, the kind of terms we use is novelty, inventive step, and industrial applicability. So first we look at novelty. An invention is novel if no single prior document discloses all of the claimed features. But what is a prior document? What is prior art? So the date that you file the application is called a filing date. If you subsequently file patent applications for the same invention in other countries, then the filing date of the first application is called the priority date. So prior documents are used to examine your application, particularly your claims. So that assesses novelty and inventive step. So prior art would include any information disclosed to the public anytime before your priority date. That's why the priority date is important. So the earlier you file, the smaller the pool of prior documents. So novelty, right? Regarding novelty, let's say you are trying to claim a patent for a hairdryer, right? And you claim a hairdryer with features 1, 2, and 3. But a single prior document describes a hairdryer with features 1, 2, and 3. It's the same, right? Features 1, 2, and 3. The font is different, just to show you that Even if it's worded differently, if it's the same feature, it's the same feature. You can't just use alternative wording to get around the novelty requirement. So this prior document has disclosed all of your claim features. What do? You can amend your claim. So one way to go about it is that you can include more features in your claim, like features 4 and 5. So now you claim features 1, 2, 3, and 4 and 5, and the prior document only discloses 1, 2, and 3. So your claim is now novel over this prior art document. Another way to go about it is to call out functional differences in your features, so that the prior features are definitely not the same as your claim features. So if your hairdryer say it has buttons on the handle, right, and the prior document has nothing about handle buttons, and then you add that your handle has buttons, so like feature 2A or 3B, right? And so now the prior document doesn't disclose all of your claim features since it doesn't disclose buttons, for example. So what about inventive step? An invention involves an inventive step if the difference between the claimed invention and the prior art are not obvious. This essentially means that someone in your industry or in your position looking to solve the same problem, it wouldn't be obvious to them to come up with the same solution that you have. So let's say you claim a table with a circular top and 4 legs, but a prior document describes a table with a rectangular top and 4 legs. So the difference here lies in the shape of the tabletop. The question here would be whether simply changing the shape of the tabletop from rectangular to circular is inventive. Is changing the shape something obvious? Probably, right? In this scenario, simply changing the shape would be a pretty natural modification. What about industrial applicability? It basically means that as long as it can be made or used in industry, any industry, provided the invention is of technical character. So this is one of the easiest requirements to meet, and the invention can really just be about genes or a device or some kind of mechanics in really any industry as long as it can be used. So we've gone over the basic requirements of a patent. Now we can move on to the patenting process. In general, the patenting process in most countries is more or less the same. First, you file. Once the application has been filed, just now we talked about the priority date. So the earlier you file, the better, right? And when it comes to filing, there are some challenges here and there because when you file, it's not just simply submitting something. You have to submit certain kinds of documents in a certain way and certain information. So it might be helpful if you get a professional to help you prepare these documents. So the next stage is search and examination. So when it comes to search and examination, first, a search will be conducted to find any relevant prior art, like the prior documents that we mentioned before. So these are documents that were available to the public before your priority date. Then your application, particularly your claims, will be examined as to whether it is novel and inventive over these prior art. So if the examiner thinks they're not, then the examiner will issue objections and say, oh, it's not novel, it's not inventive for this and this. Then you have the chance to respond to the examiner to convince them that it does meet the criteria. It is in fact novel and inventive. This is usually the most challenging part of the process because at this stage, usually there's deadlines to keep track of and you may not be able to easily address the objections or convince the examiner. And sometimes due to poor patenting strategy or responses that don't really address what the examiner is looking for, a lot of companies and startups can find it difficult to sustain because a lot of money goes into it. So it would be a good idea, especially at this stage, to get a professional to help you through this process. So if you've convinced the examiner and the objections have been resolved and the examiner is convinced, then we can proceed to grant. So a patent grants you protection for 20 years. So you'll be paying maintenance fees until the end of 20 years. So for most countries, it's on a yearly basis. Meanwhile, during this whole patenting process, the examination and everything, your application will also be published. So I put this separately because this happens separately from the examination stage and the grant stage. So even if there are objections or no objections or whatever, wherever you are in the process, the publication still occurs. So say in Singapore, how long would this process take? Generally in Singapore, after you file, then it'll be published after about 18 months, right? This is typically 18 months from your earliest filing date. And at the same time, you have up to 36 months to initiate the examination process. Okay. You go through the objections and responses, and then after the back and forth, then you can have your patent, maybe after 48 months. So usually the entire process is like 2 to 4 years. And then after that, it's just the yearly renewals. So now we know about the general patenting process, but what about that first step, the filing? How do we go about that? First, it's important to know that patent protection is territorial, which means that patent protection is only within that particular country. So what about your first application? The first application can be filed in any country. Usually, people will file in their own country first. So say it's a company or inventor in Singapore, then the first application you file is in Singapore. Alternatively, you can file in another country. So maybe you don't have operations in Singapore. Maybe you intend to really launch in China first or something like that. Then you can file in another country first. And another option is an international application. So this is also known as a PCT application. So we'll get to this in a bit. But you should know that if you are residing in Singapore, then if you want to file the first application overseas, then you need to get written permission from IPOS. So this is for the first application, but how do we go about filing subsequent applications overseas? One way is with the Paris Convention or World Trade Organization treaties. So this is known as filing a domestic application or convention applications. For this, the filing date of the first application in a member country is the priority date for the subsequent application in another member country. And it must be filed within 12 months. So to give you a visual representation, right? See, if you file a first application in country X on 12 November this year, for example, then you have 12 months to file an application in a subsequent country Y. Then it can claim priority to the filing date of the first application in country X. So even though the filing date in country Y would be 12 November 2021, the priority date would be 12 November 2020. So this thing where subsequent applications make use of the first application filing date, this is known as claiming priority. So subsequent applications claim priority to the first application. So they benefit from the earlier priority date. So you have a smaller pool of prior art. So that was domestic applications. What about PCT applications? So a PCT application reserves the rights of the applicant in each member country, and it gives you 30 months to decide on the countries you want to file in. But it's important to note that this is an international application, but it does not in itself confer worldwide protection. It's not a single application that gives you patent protection in every country. So you can file a PCT application and then in 30 months file in all your chosen subsequent countries. This is known as entering national phase because the PCT application part is called the international phase. So when you eventually file in the chosen countries, then it's the national phase. But PCT application doesn't have to be your first. You can also file in a first country, maybe country X, and then file a PCT application within 12 months. So it still has to be within 12 months if you're not filing a PCT application first. And then you have the additional 18 months, which makes a total of 30 months from the earliest filing date to file in other countries. So now it's time to decide which countries to file in. You have your specification all ready to file, but which countries do you file? Which one first, which one next? We're going to go over some considerations that may help you with these decisions. But first, I want to reiterate that patent protection is territorial, which means that if you don't have a patent in that country, you don't have patent protection in that country. So moving on, what exactly is patent protection then? What are the rights you have as a patent holder? You have exclusive rights, which means that you have the right to exclude others. So you can exclude others from doing certain things regarding your patented invention. You can stop others from certain actions. And these actions include making, selling, offering to sell, importing, keeping, and using your patented invention. But these rights are not indefinite. It lasts for 20 years. But keep in mind that these are negative rights. They give you the right to stop others, but it doesn't necessarily give you permission to do things. So even if you have a patent, and it's still possible for you to be infringing someone else's patent, even if your patent is for the same thing or same thing plus improvement. You know what I mean? So with those rights in mind, there are two key considerations when you think about where to file. Where are you doing business? Where are you making your product? Where are you selling your product? Where might you expand? And where are the people that you want to prevent from exploiting your invention? So these are the people that you want to prevent from doing certain things, right? And usually people in this category are your competitors. So let's say your patented invention is an end product, like the bottle, right? And you're going to handle all the selling and supplying yourself. So let's just take this as an example and we'll go through with it. So an easy way to think of potential countries of interest to look at your supply chain. A simple supply chain usually has a manufacturer, which just does the making, right? And then you have distributors and retailers. These are basically sellers. And then you have the shoppers, which are end consumers, like you and me when we go and buy random things from a department store. So simply put, the supply chain is basically made up of makers, sellers, and buyers. So what about the manufacturers? Start from the top. Remember the exclusive rights that you have. What do manufacturers do that you can stop? They make and they keep. They keep the products before they send them out. So this may be one of the more important considerations, because if you ever find yourself in a situation where a competitor is producing your product without your permission, it would make sense to nip it in the bud just by killing the source. So when you think about a manufacturer, which countries should be of interest? Where are these manufacturers? So first think of where your manufacturers will be, because they'll be producing your product. They'll have access to it. They'll know how it's made. And say your manufacturer is in China. Maybe you want to have protection in China. But another consideration is where your competitors' manufacturers are. If your competitors wanted to sell your invention without your permission, then they'll need their manufacturers to make it. So maybe some competitors are in Vietnam and some have factories in China. So maybe add Vietnam to that list. And then another consideration, which may sometimes be overlooked, is potential manufacturers. Because the manufacturing industry is not static, right? So if everyone is manufacturing in China and Vietnam now, who's to say they'll be manufacturing in China and Vietnam next time? So maybe there are burgeoning manufacturing countries like Malaysia or Thailand. Then you might want to add these countries as well. So what about distributors and retailers? What do these groups of people do that you can prevent? They sell, they offer to sell, they keep inventory, and they import. So think about where you sell your products or who distributes your products. Maybe you have operations in Singapore and then you plan to sell in Singapore and Malaysia. And what about your competitors? Maybe your competitors have operations or have presence in Singapore, China, and US. And again, it would be helpful to think of potential markets. So maybe your competitors or you have plans to expand to other countries, Thailand, Indonesia, US, Canada. And these may potentially be countries you want protection in. But it's also possible to offer to sell to the entire world. But we'll talk about that in the buyers section. So buyers are the end consumers, the regular shoppers, right? These are the people who buy your products to use and keep, like how I bought my water bottle. And the countries where your buyers are can be specific countries. Maybe you only operate in brick and mortar stores, and then you only have Malaysia and Singapore. Or your competitors could be the same. Maybe they only have certain places. Or you or your competitors or anyone else could potentially just sell it to the entire world. Say if you sell it online and it's just available for any buyer in almost every country, right? Worldwide shipping is a thing nowadays. So the countries concerned when it comes to people who may buy a patented invention would be anywhere, essentially, if you offer it online. So now you have that whole list of potential countries to file in. Should you file in all the countries, which is like every country? Not necessarily. So there are some further considerations which might help you to narrow down the list of countries. First is cost. Obtaining patent protection is quite costly. It is important to notice to consider the potential cost. So like, for example, cost per country. Filing an application alone can cost a few thousand, maybe getting it to grant a few more thousand. Some countries can cost a lot more, maybe generally high fees, translations, conversion rates. Some countries are also stricter when it comes to patentability, so the examination stage would usually be more rigorous and more costly at the same time. So keep in mind that patent protection is territorial, so when we're deciding on countries, the more countries you want to file in, the more it's going to cost overall. So if you file in 20 countries, then the total cost may be spread over various stages throughout the application process, but at the very least, the filing is going to be a large sum at one time. Another cost to think about is maintenance. So don't forget that when the patent is granted, you still have to pay maintenance fees. So in most countries, it's an annual fee, where it gets higher and higher the closer to 20 years that you get. But it's not all about expenses or costs. Sometimes it's about money coming in. So consider funding. Where is the money coming from? Are you pre-revenue? Do you have investors? Do you have funds set aside for IP protection? These are things to consider. Like, for example, there are government grants. Like Singapore has a market readiness assistance grant, which can help Singaporean SMEs cover the cost of overseas patent applications, or at least help with the cost. So these are things to consider when it comes to the cost. Another consideration is the product life cycle. So you know that a product's life cycle is basically from introducing it to the market until it's taken off the shelves or when it's no longer relevant in favor of better or trendier products. So some products have very short life cycles and others have long life cycles. So short life cycles can be seen in like high technology where everything is improving at a super fast rate. And on the other hand, there are products with longer life cycles. Like if you have a breakthrough robot type technology, then having such a model in 2020 would probably still be very relevant in 2024 because that kind of technology doesn't move as quickly. So how would a product life cycle impact the countries that you choose? Well, different countries have different timelines, so to speak, as to when your patent could be granted. Some countries like Singapore, it takes 2 to 4 years. But in other countries like maybe Brazil, right, it can take 10 years. But fortunately, the countries where people tend to file, like, China, Europe, US, Singapore, these tend to be shorter, like 2 to 4 years is quite normal. So if the product life cycle is short and getting a patent in a certain country is double the life cycle of your product, then you have to balance whether or not you really want to file that. And another consideration is enforcement. What about enforcement? In a very general sense, enforcement would involve taking legal action against people who may be infringing your patent. So in terms of considering the countries to file in, it would be helpful to consider who you would reasonably enforce your patent against. If a competitor is selling your patented invention without your permission, then it would make sense to cut the head of the snake and take action. You stop the competitor and you stop their manufacturers. But would you really go after the buyers all over the world, the individual end consumers who buy one product? Going after them, would it stop the distribution of the unauthorized product? Not really. So consider whether you really want to protect in countries where there are only buyers and where you do not foresee there to be anything else but buyers in that country. So if you don't think sellers or manufacturers will move there, then maybe just leave the buyers to do their thing. So that's a consideration. So this is a consideration because, like we said, there's a potential for the entire world to be your buyers, right? So because of reasons like cost, maybe it's not feasible to get protection in every possible country. And usually people don't get protection in every possible country. So this may help to bring down the list of countries from the entire world to maybe just the countries concerned with manufacturing, selling, and maybe the primary or larger consumer markets that you may or may not expand. So another consideration is commercialization plans. It's important to have a plan on how to commercialize the patented invention, since getting a patent itself can be considered an investment. So if you have no plan to commercialize it, then it could just turn out to be a useless patent. So if your commercialization plans don't have any kind of manufacturing or markets or competitors in certain countries, then of course those countries would be lower priority when you're selecting which countries to file in. And another main thing in commercialization is selling the product. So this can include manufacturing, distributing, selling, all of that. Basically being the master of how your product gets around. Another thing is licensing. So this means that the people you give the license to, the licensees, they would not be excluded from making or selling or whatever else that you allow them to do. So licensing can be a primary way of commercializing as well, because if you let, say, an incumbent company license your patent, then you get royalties from it while they handle all of the distribution and marketing and all of that, getting it out to the world. Licensing can also be in the form of cross-licensing, which can help you and your competitors find a middle ground when you have very similar patents. So like Samsung and Apple, they actually cross-license a lot of their patents as a sort of bargaining chip so that they don't end up suing each other. So, but other than that, licensing would anyway usually be part of the general commercialization plan anyway, because you would need to license your patent to manufacturers and all that so that they're allowed to make it. And maybe distributors so that they can import it and sell it in other countries where you are not. So other than these licenses for your manufacturers and all, if licensing to other people is part of the plan, then countries of interest to those people, like maybe the incumbents, the countries of interest for them should be considered as well. Or maybe at the end of the day, you find that you move on to a bigger, better project. You don't want to spend any more time on this patented invention, and you don't want to deal with it. You don't want to deal with licensing, you don't want to deal with any of the maintenance and all that. Instead of letting it die, you can just sell the whole patent. So you wouldn't own it anymore. So similar to the licensing plan, if you think of selling the product, maybe you think you may want to sell the product, the patent entirely, then think of the countries of interest to the people who would want to buy your patent. Maybe the incumbent companies, maybe up and coming competitors. Did you know that GPS was patented? Everything is GPS now, right? Can't imagine life without it actually. But it initially became a huge thing like in the 90s or something, but it was actually patented in the 70s. So by the time it became mainstream in cars and phones and all of us knew about it, it would have made so much money. The patent had already expired. So if the commercialization plan had been different, maybe the original inventors may have really benefited a lot more from it. So just think about that. Commercialization plan is very important. So now you have your plan. How do you decide which countries to file in? Using the earlier example, we have a list of potential countries to file in, right? We have China because of manufacturing, Vietnam, Thailand, Malaysia, manufacturing, and then we have the sellers. So you have operations and potential operations. And then you have buyers. So could be worldwide, like we said, but you can't possibly file in every single country, right? So maybe we can break down worldwide into a collection of countries where people buy your type of product in general, maybe Australia, Japan, UK, just for example. So now you have 11 countries on the list. Maybe this is too many for you. You don't want to handle so many, maybe you don't want to go through so many processes for 11 countries. Maybe it's too costly. Maybe you don't foresee there being enough buyers in Japan and Australia that would influence competitors or your own company to actually go there. So then they would just be buyers and nothing else. Then maybe if the market's not so huge, take them out. And then maybe Thailand, maybe there are a lot of manufacturing opportunities in Thailand, but then you found that it's not so big for your industry. Maybe your industry manufacturing doesn't really do it in Thailand. So then you can take Thailand out of the mix. So now you have 8 core countries, more manageable. So we take these 8 countries as your chosen countries. The next step is filing. So now we move on to discussing international applications versus domestic applications as part of the filing strategy. So first, what is an international application? Like we said before, international application is the PCT application. And we talked about how you have 30 months from the priority date to file applications in your chosen countries. The PCT has about 150 member countries, it pretty much covers all the countries that people usually want to file in. But remember, there's no international patent. There's only an application, and it helps you get to where you want to go. Getting actual patent protection is still country to country. So how the PCT process works is slightly different from the typical patenting process that we showed earlier. Also, since it doesn't actually get granted. So just keep that in mind. So when you file a PCT application, you have to request for a search at the same time. It's just how it works. And as mentioned before, publication will happen after 18 months. So once you file the application, then it'll undergo search and examination, and then it has objections. So a search report will be issued and may come with objections for novelty and inventive step and other issues that it might have. So responding to these objections for a PCT application is optional. You do not have to. So eventually, there will be a preliminary report on patentability which will be issued. So this is basically like an examination report showing whether the examiner thought it was novel or inventive and other requirements. So it could be the same as the initial objections if you didn't respond, or it can be the examiner's opinion after consideration of your response. So this is usually the last event in a PCT application before it's time to file national phase applications. So that was PCT. A domestic application, like what we said, is where you have 12 months to file, whichever country, as long as they're part of the Paris Convention or World Trade Organization. And as you can see, the process for a domestic application is pretty much the same. That's the typical patenting process. It's slightly different from the PCT. So in terms of the 8 countries we had earlier, you have the option of filing in all these countries using PCT or domestic routes. Say if you use a PCT route, then you can file first an application in Singapore and then within 12 months, file a PCT application. And then after that, you have that additional 18 months to file in the remaining countries of interest. Or you can just file a PCT application and then national phase into all the countries. So these are the ways you can use the PCT route. But for domestic, it's more straightforward. You file the first application and then all the subsequent applications within 12 months. Filing so many applications, as you can see, right, it can be quite overwhelming, especially keeping track of the individual deadlines for the local requirements in terms of additional documentation depending on the country. So it would also be helpful to get a professional to help you to manage this so that you don't miss any deadlines. So now I'll highlight some differences between international and domestic applications, just to kind of, weigh between the two options, because they can be quite different, even though they are somewhat similar as well. So keep in mind that consideration of international versus domestic applications in this context is in the purpose of filing subsequent applications in multiple countries. So this has been mentioned a few times. A PCT application, you have 30 months from the priority date to file in other countries. So it's 30 months from your first application. So whether the first application is Singapore or PCT or whatever, is 30 months from that date. And a domestic application gives you 12 months. Another difference is that a PCT application on its own doesn't confer patent protection. It just kind of paves the way, whereas a domestic application is a direct application in that country, so the result will be an expected patent. Another thing is that PCT applications allow for easier filing process when you start filing your national phase applications. This is because there are a lot of documents and information that are already in the PCT database, so an individual patent officers won't require as much most of the time. Whereas if you file direct applications in each country, they don't have that consolidated database to refer to, so they require again and again and again the same information, the same documentation. And also, for PCT applications, there's a certain formatting requirement in terms of how your specification is done. And if you meet those requirements for PCT, then in essence, all the national phase countries have to accept it in that format. Whereas if you do domestic applications, you have to change every time to suit the local requirements for how the formatting is. So that's one thing. And the other thing is that with PCT, national phase applications at the end of the 30 months can only be filed in the member countries, which is 153 countries. It's basically usually what you would need, actually, Europe, Southeast Asia, US, China, India, subcontinent. But domestic applications can be filed for countries who are party to Paris Convention or World Trade Organization, which is many more countries. So most notably, Taiwan is not party to the PCT. So if you want to file a Taiwanese application, then you would have to go through the domestic route in order to file in Taiwan. So like the 30-month, 12-month deadlines, right? With a PCT application, you have more time to decide on filing countries. And so you can solidify your filing strategy and more time to amass funds and plan your marketing. So if you were to file domestic applications, it's kind of like initiating the patenting process sooner, so to speak. So you'll be filing within 12 months instead of 30 months. The good thing about this is that because the process is already started in your chosen countries, then you may also end up getting your patent sooner. Preliminary examination results for PCT application, like we mentioned earlier, is conducted to assess patentability. So the perk of having a PCT application is that once the examination result is out, you have a rough idea of how successful your applications might be in the various countries you plan to file in. If the examination result is good, novel, inventive, it's great, looks good, then you may feel more confident in investing in filing in the other 7 countries or the other 8 countries, right? And some countries with less stringent examination procedures, they may even just accept the positive PCT results. So that's beneficial. On the other hand, filing domestic applications doesn't involve preliminary examinations. So if you file everything within 12 months and you don't have any result from your initial first application, then you're going in without knowing how the examination might go, how the result might be. So if you've decided on the countries and you know the options available to you through PCT or domestic applications, which one should you choose? So 2 main considerations, I think, for whether you should file PCT versus a domestic application. First is, what is your timeline? We talked about commercialization plans. And if your timeline is not so rushed and you have a long-term plan or the strategy allows for extending the time before you file in subsequent countries, then a PCT application could be beneficial. Or if you need more time to decide on the countries or the product is not yet ready or you're relying on investors, then the extended period that a PCT provides could be beneficial as well. Alternatively, if you're looking to get a granted patent sooner rather than later, and you want to have a patent pending in your countries of interest, then you could go for domestic applications. You can always file a national phase application earlier than 30 months, but if you file your national phase applications very, very soon, like 12 months, 15 months, then it kind of defeats the purpose of having the extra 18 months and having that examination result from the PCT. So then you might as well just file within 12 months in domestic countries. But with time sensitivity, it doesn't make a huge difference when it comes to your rights, because with PCT, your rights are reserved in the member countries anyway. So even if you file later on in 30 months, when you ultimately get the patent, the rights are the same. It might be a more sensitive decision if maybe you want to say you have a patent pending in a specific country. Then you might want to have to file that earlier. So the next thing is, how many countries do you intend to file in? So we showed the filing process earlier, and filing a PCT application basically adds one round of filing between your first application and your subsequent applications in more countries, unless the PCT is your first application. So if you intend to file subsequent applications in several countries, maybe like 8, like we were talking about, right? Or maybe 10 or 5 even, then maybe a PCT application might be more beneficial since it gives you the additional time and also a rough overview on the patentability of your invention before you file in so many countries. And then it may be easier to file each application, like we said earlier, because the process is a bit smoother. And if you're filing maybe just 1 or 3 subsequent applications, then it may not be so beneficial to go with the additional round of filing with PCT, unless you really want that preliminary report on patentability before filing anywhere else. So then you can just file domestic applications directly. So we have these 2 primary considerations to decide PCT or domestic. You have a plan, you have your countries. Now you can decide if you should file a PCT application. So hopefully that was helpful. Thanks.